I heard an old classmate was arrested for armed robbery. They mentioned a detention hearing. What's that?
In Illinois, when a person is arrested for certain crimes, at the first court date, the prosecutor can file a petition asking a judge to hold the defendant in jail until trial.
What's a petition?
A petition is a written request for the court to take specific action.
So, if the prosecutor files this petition, the judge just says lock the person up?
No, it's not automatic. The hearing must be held.
What's in this petition? What the police and the media say happened?
The prosecutors say which crime the defendant is charged with that caused them to file the petition. Only certain crimes qualify, like murder, attempted murder, armed robbery, domestic battery, and some gun crimes. There's a long list of crimes. They also must tell the judge and the defense attorney the facts of the crime the defendant allegedly committed. This information comes from police reports and sometimes eyewitnesses, victims, and even the defendants themselves.
So the defendant is basically found guilty at the first hearing.
No. Under the laws of our country, every defendant has the presumption of innocence unless he or she or they are convicted at a trial or plead guilty. The detention hearing is not a trial.
When you say prosecutors must show, what does that mean?
Under Illinois law, only prosecutors can ask a judge to keep someone in jail before their trial. They must prove their case with clear and convincing evidence. This is a high standard of proof, more than in typical hearings, but less than at a trial. Simply put, it's the prosecutor's responsibility to show to the judge why someone needs to stay in jail before their trial.
So the prosecutors just tell the judge the crime and the facts, and the defendant gets locked up?
No. In Illinois, defendants have the presumption of release. This means the judge is required to assume that every defendant should be released until their trial. The judge can release a defendant with conditions. Conditions aim to balance the presumption of innocence with ensuring that the defendant will return for trial and not pose a risk to public safety. If prosecutors file a petition for detention, they must also prove by clear and convincing evidence that the defendant should be locked up because he or she or they are dangerous or might willfully flee Illinois, and there are no conditions or combinations of conditions that can lessen that.
Do only prosecutors talk at these hearings?
No. The defendant's attorney is also involved. The defendant has a lawyer present who argues on his or her or their behalf. The prosecutors must share all evidence with the defense before the hearing, including reports and witness statements. Defense attorneys can challenge the prosecutor's claims about the crime, the defendant's danger level, and whether conditions could ensure they return to court and avoid new crimes. They also provide the court with details about the defendant's community ties, job, family, education, and other relevant factors.
So, what exactly do the prosecutors have to prove at these hearings?
First, the prosecutors must convincingly show that every element of the charged crime is met. This means they need to provide clear and convincing evidence that the defendant committed the crime as charged. They must also show that the defendant is a real and present threat to a person or the community. This isn't just about the crime itself, but involves the prosecution explaining how the defendant's release could be dangerous. Finally, the prosecutors must prove that no conditions or set of conditions, like pre-trial check-ins, a curfew, or electronic monitoring, can lessen the threat of harm to a person or the community. State law mandates that detention is only used when absolutely necessary to protect people and ensure the defendant's appearance in court, balancing public safety with the defendant's rights.
What happens if the prosecutors don't clearly prove the charged crime, or if they only prove a lesser charge that doesn't allow detention?
If the prosecutors fail to meet their burden of proof, the judge must deny the detention petition. This means the defendant would be released, possibly with conditions such as regular check-ins with a pretrial services officer, GPS, or electronic monitoring to ensure the defendant returns for future court dates and doesn't pose a threat to others. For more information or to read the full detention statute, the Illinois Pretrial Detention Statute can be found at 725 ILCS 5/110-6.1 subsections A1 through A8.